Hi, everyone. Thank you for joining us today for Constangy's webinar, Under the Microscope, How High-Profile Investigation Failures Shape Best Practices. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat. You can access the chat through the toolbar located at the bottom of your screen. Our presenters may not be able to address all of your questions during this session, but we encourage you to reach out following the presentation. Their contact information will be included in our post-webinar follow-up email. This program is approved for SHRM and HRCI credits. We will be sharing those codes at the end of this presentation, so please stick around in order to get them. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Taren Greenidge and Sasha Thaler.
Good afternoon. Thank you so much for joining us today. We look forward to chatting with you and having you for some time to talk about investigations and how these high-profile investigations can teach us things and what we can learn from them and how we can adapt our own practices moving forward to better align with high best practices. We also, today, obviously, myself, Taren Greenidge, I am a partner and investigations co-chair, along with my co-chair who will be presenting, Sasha Thaler, as well on the call today. We are excited to share some of this with you and talk through with you. Obviously, just a quick caveat that unless we have a formal representation with you already, this is just general advice and should not be construed as legal advice unless you retain us formally, and we can obviously assist you at that time.
So today we're going to talk through a few investigations that have made local and even national news in some litigations across the country. And we'll talk also not only about what happened in those cases, obviously, or what's still happening in those cases, some of them are still ongoing, but also give you some ideas about how to think about investigations, how to think about structuring them, and some pitfalls to look out for. So the cases we're going to talk about are the ones listed on this slide. And I just wanted to give a quick overview of the cases before we launch into the specifics. These really are very recent matters that have come up. These are in some cases still ongoing live matters. So obviously we don't necessarily know all the facts of the cases that may come out in litigation as it may continue. But we certainly want to point out some potentially headline grabbing aspects of these cases. The first one we'll talk about is the Mohammed versus SHRM, which most people on this call will know is the Society for Human Resource Management. And they got into the news because of a truly eye-popping jury verdict, as you can see here, $1.5 million in compensatory damages, $10 million in punitive damages, largely because of what the jury considered to be missteps relating to an investigation that was undertaken internally and sort of related issues that arose. I will just say that what we will talk about in this matter and in all the other ones, certainly the facts are crucial in all of these, and what a jury may decide at one situation may not be end up being what the outcome is for another situation, because the facts will be different in each case. But we talk about these obviously to give folks an idea of the kinds of issues that juries may be thinking about, and certainly the kinds of issues that plaintiffs may be thinking about. And so in particular, the second case we'll talk about is the Sabatini case. There were three defendants there. The title is one of the defendants, but the other two, and the one was an individual employee, but the other two were the director and the employer. And in that case, the outcome ended up positive for the employer, but it didn't stop the employer making the news over the investigation and sort of issues that arose in the investigation. And then the other two that we'll talk about are more recently filed cases. The Carrion case versus Citigroup that was filed toward the beginning of this year. And while it is currently in a bit of flux because the defendant is seeking to move it to arbitration, there are certainly already important lessons to be learned from at least the allegations in the case about how the investigation was conducted. And then, frankly, just sort of hot off the presses, just last month, there was a case filed in my backyard in Massachusetts, again, identifying a potentially problematic investigation as being sort of one of the driving forces for the litigation. So we'll walk you through these cases, the facts as they came out in the litigation, or at least as they are known to us at the moment based on the filings to date. And then, of course, we will spend some time talking through kind of what are the lessons learned from all of these, what are some best practices that we can share with you all to hopefully maybe avoid some of the drama and publicity and attention that can come from some of these missteps that are discussed in these cases.
Perfect. So we'll start off by talking about the Sherm case. And so in this case, it was filed in federal court in Colorado, and a former employee brought this claim against Sherm. The individual, she was an Egyptian American instructional designer. She was claiming retaliation based on race claim that she claimed that she made prior to the end of her employment, and also alleged that she had earlier performance reviews that were very positive until she was assigned a new manager who treated white employees differently. And so talking through, a lot of the claims here and understanding kind of, a little bit more about this case. Obviously, this case came out in December of 2025 and ended with an $11.5 million verdict. And so it got a lot of headlines, and we thought it would be an important one to talk through to, we learned a lot through the holding in this case and through the determination and outcome about different things that the plaintiff's counsel in this case tried to attack relating to the investigation. And so just want to have an opportunity to talk through kind of what did we see here in this case. So the court appeared to take issue with a number of things with the investigation, including the initial reaction to the complaint. So the manager that received the concerns, which was a skip level manager, initially tried to just facilitate a mediated conversation instead of directing this matter to an immediate investigation. And so there was an attempt to have the employee and the alleged bad actor talk it out, right? Where there was claims of retaliation and discrimination, there was an attempt to just have them have a conversation, seemingly with the idea that they would be able to talk it out and resolve the issue without actually bringing in a neutral fact finder to assess the merits of the allegations or understand the details and facts of what happened, and without the opportunity to take any kind of action that might have been appropriate, right? So this idea that we can avoid an investigation and instead just try to have the parties talk to each other, the court did not take kindly to that idea. And so that also held up the process quite a bit, right? Because that meeting was scheduled and held in advance of starting off and initiating the investigation. Another big factor here that had an impact was that the investigator who was assigned to the case did not have a whole lot of experience and frankly had no discrimination investigation experience. What came out in the facts of the case were actually that the person had only participated in one training prior to being assigned to investigate this matter, and that they couldn't recall the details of the training and they didn't really recall the specific facts or information that was shared, and instead just kind of were, making it up as they went along a little bit because they just did not have the amount of experience that one would expect of an individual who has been tasked with investigating, a multifaceted and multi-level complaint. Another one of the significant issues was evidence that the investigator was also assisting the manager who was accused of with the actual management of the employee. So helping to ghostwrite emails regarding performance deficiencies and other conduct issues of the individual employee who made the complaint, as well as assisting with drafting termination paperwork for this person. So essentially, the case that one of the main issues was that the investigator, who's supposed to be a neutral fact finder, was clearly kind of aligning with one side and assisting the alleged bad actor with formulating responses and creating a paper trail associated with kind of making out a case for the termination of the employee while also investigating the claim. And so it really went to neutrality as well as just a kind of a conflict for that particular investigator. This certainly gave the appearance that the outcome of the investigation was predetermined, and that definitely seemed to be detrimental to the analysis or assessment of the investigation that was conducted. The employee also brought forward retaliation concerns during the investigation, and they were not added to the investigation. So instead, on the same day that the retaliation claims were brought forward during the investigation, the investigator assisted with drafting the termination paperwork. And so they did not expand the scope of the investigation to include these new allegations at all, and really did not look into those claims during the course of the investigation and while it was being conducted. The investigation was also criticized for not having sufficient documentation. There was really an absence of kind of robust records, which seemed to raise some questions about what specific steps were actually taken, what evidence was reviewed and considered, and how the conclusions were reached. So it goes back to really the importance of ensuring that we're maintaining sufficient documentation during the process of the investigation. A lot of times you're seeing litigation come many years after an investigation is conducted. And so sometimes the employee, if you had someone internally conducting the investigation, may no longer even be with your organization. And so the documentation that is collected during the course of the investigation, kind of real time, is going to be incredibly important because it will really create the storyline of what happened, the who, what, where, and when as it relates to the investigation. And it will also help because sometimes we just can't recall the specifics, right? If you have internal or external investigators, usually they're conducting a lot of investigations. And so if they cannot rely on a specific documented record of what happened, a lot of time they're having to fall back on their memory, which is not what you want in high stakes investigation. You really want to ensure that the steps are outlined as part of the report potentially, or in some other notation that you keep as it relates to the investigation about the decisions that were made related to who was interviewed, what documentation was requested, collected, or reviewed, and the information about the specific allegations that were brought forward and how determinations were made. We'll talk more about one of the other investigations, particularly where an issue came out relating to not making a decision to not interview particular witnesses that the person who brought forward the complaint instructed the investigator to interview. And so, if we don't have documentation to explain why some of those decisions were made, they can sometimes seem arbitrary after the fact. And so this case really talks a lot about thinking about experience level, ensuring there's a level of neutrality, and also making sure that we're documenting every step of the way, not just your final decision, but how decisions were made to lead you to that decision, what was considered and what was not considered, and why.
Exactly. As a quick reminder, feel free to jump in if you have questions. You are welcome to hold them to the end as well. Either way, we'll do our best to address them at the right moment. But next, we wanted to move on to the Sabatini case. So as I said, in this case, there were three defendants, another employee named, so the plaintiff's name was Dr. David Sabatini. The three defendants were Dr. Kristen Naus, Dr. Lehman, and the Whitehead Institute. I do want to back up a tiny bit because there is quite a lot going on with this situation. I think it helps to have a better understanding of the case or of the dispute between these parties overall before launching into the investigation specifically. So the zoomed out background here is Dr. Naus was a graduate student and later a researcher at the Whitehead Institute for quite a number of years. Dr. Sabatini was also a researcher, a scientist associated with the Whitehead Institute, and they overlapped. After some period of time, they did eventually engage in a sexual relationship. There is some dispute between the parties about to the extent to which it was a consensual relationship that's sort of tangential or maybe not directly related to the overall dispute, but it is certainly related. But the significant issue here was that Dr. Sabatini had a very high role with the company, an executive level role, and Dr. Naus was an employee under him, and more specifically in his lab. So during her employment, her time at the lab, there were two complaints that came from other employees alleging that there was basically a sexualized environment in Dr. Sabatini's lab. And after Dr. Lehman became the executive director, a culture survey was commissioned that also seemed to suggest additional information along these same lines, and particularly that Dr. Sabatini's lab was a sexualized environment in various ways. Because of this information, at least according to the defendants, they engaged an outside law firm to conduct an investigation to better understand, what may be going on, what might have been causing these concerns to be brought forward. So now we come to the investigation. This was an extensive effort undertaken by multiple lawyers at this outside firm. They reviewed, I believe they interviewed something like 43 witnesses. They collected something like 1 million documents. And ultimately, after, of course, quite a number of months of effort, they produced a 120-page report. So certainly to Taren's very recent point, they had the documentation piece fairly well covered on this one. The report came out with a number of findings regarding Dr. Sabatini, and in particular, that he had violated various Whitehead Institute policies, and also that he had actively interfered with the investigation as it was going on. Certainly during the investigation, multiple people provided information to the investigators, including Dr. Naus, and some of that information related to their relationship, to interactions that the two of them had had. In any case, based on the information that was derived from the report, Dr. Lehman and the Whitehead Institute decided to terminate Dr. Sabatini. That is all the foreground. So what happened next is Dr. Sabatini went on the offensive, and he alleged that in conducting or overseeing the investigation and in taking actions after the investigation, the defendants had engaged in defamation. And he also claimed that he was discriminated against in the course of the investigation and in the decision-making around the investigation because of his gender. he alleged that the investigation overall was a sham investigation and that it targeted him based on his gender. As part of all of that, he sought to discredit the investigation. And in particular, he engaged an expert who is himself an investigator who opined on the report and the procedures that were taken in the course of the investigation as they were outlined in the report. So what was interesting about this case was that the investigation, the way it was handled, the decision-making around it, all of these things were sort of very front and center for the court to be reviewing. As it turns out, although the expert had identified quite a number of flaws in what he considered to be flaws in the investigation, the court did ultimately find that although the investigation was, quote, not perfect, it was not ultimately a sham. And so Dr. Sabatini's claims were not successful. And I do just want to pause here and point out, certainly, that in the world of workplace investigation, perfection is not required. Employers are expected to act in good faith and to make reasonable decisions based on information that they reasonably gather in the course of a reasonable investigation. I'm sort of using that word reasonable multiple times to emphasize that there's not necessarily a legal standard of sort of perfection here. Having said that, part of what we're trying to do today is to talk through, potential pitfalls that can happen in investigations so that you are well armed to be preparing for them in advance. So what exactly were these, maybe you can call them pitfalls, but at least the issues that the expert investigator identified that, at least in his opinion, had arisen during the investigation? So one was very similar to what Taren pointed out in the prior case that she discussed, a lack of promptness in beginning of the investigation. As I said, there were a couple of complaints. There was a culture survey, and that took some time. There were maybe indications that other complaints had also sort of been made in the course of time, and the investigation didn't begin immediately from those. The expert also said that the investigators who conducted the investigation were not sufficiently trained. The specifics of that were certainly debated by the rebuttal expert, and certainly there is no particular legally required level at which an investigator is supposed to be trained, or that might be considered sufficient. In the case that Taren discussed earlier, the facts indicated that there really was just one training some months ago that the individual didn't remember. I think most people would consider that is quite a low level of preparation for a task as important as acting as a neutral fact finder. Whether or not the investigators in this case were, quote unquote, insufficiently trained, certainly the court ultimately didn't agree with that, but it became an issue that the plaintiff tried to use. There was a question about whether the investigators had understood the policies that were being applied to the investigation, and in the course of the investigation and in making determinations about whether the policies had in fact been violated. It sounds maybe a little bit obvious to say, but it is pretty important for an investigator to be able to feel comfortable that they know which policies are at issue, that they understand what those policies are, because certainly the questions that will be asked in most cases at least should be fairly closely related to the policies that are being reviewed. The expert also considered that the scope of the investigation was not sufficiently wide, and considered that concerns that Dr. Sabatini had raised. should have been, but were not considered or addressed in the course of the investigation. I don't want to belabor every single one of these too closely, so I will just sort of reference that there was a quite a long list of issues. We can again treat each one of them as it is sort of appropriate. Some, not all issues are going to have the same weight. But for sure, something like treating the parties consistently is going to be something that becomes quite important, right? If the complainant is treated more harshly than the respondent, or vice versa, it's going to potentially lead to claims that either the outcome of the investigation was predetermined, or the person conducting the investigation was biased toward or against one of the parties, neither of which is helpful if you're, as an employer, if you're trying to rely on the outcome of an investigation to make decisions. Certainly being mindful of the way that questions are phrased, that was another area that the expert dinged the Whitehead's report for, and based on the reports back from several of the witnesses who considered that some of the questions had been seemed to have the response sort of predetermined, or seemed to have an outcome that they were expecting to hear in the way that the questions were phrased. Again, suggesting a lack of neutrality, and potential indication that the outcome of the entire investigation was predetermined. There were also concerns raised by the expert regarding whether, despite having interviewed 43 people, whether the investigators had actually sought to speak to all the relevant witnesses. And as a brief preview, this is an issue actually that comes up in another case that we'll talk about, where there was a question about, well, having interviewed all these people, were those actually people that needed to be interviewed? And so it is important to be thinking about who all actually needs to be interviewed. Has everyone who may have relevant information been reached? Have individuals identified by the respondent and the complainant both been considered at least and reached if appropriate? Questions like that. Documentation issues and failure to rely on credible evidence and to make credibility determinations. These were all issues that the expert raised, and believe it or not, I did not even cover all of the issues that the expert pointed out that he considered to be failings in the report. The good news, as I said, for the employer in this situation was that the court, even considering all of these purported failings, decided that the investigation had not been a sham. As I said, there certainly were a lot of interviews, a lot of documents reviewed, a lot of sort of painstaking review of the evidence overall. And despite, for example, a couple of people complaining about the way the interviews were handled, there was not an overall sense that the investigation was a sham. But the court did note that, the investigation, quote unquote, wasn't perfect. And it did end up being central to this pretty high profile litigation that was brought by an individual who himself had been the target of the investigation. So a lot to think about in terms of what are good practices for an investigation from this case.
And the next case that we'll talk about is the Carrion versus Citigroup case. This was filed in January of 2026 in a federal court in New York. And so the information that we'll discuss about this case is solely based on the allegations that have been asserted, as this case is really only in the preliminary stages. And so On the employer defense side, we know that allegations can be made in court pleadings without verified evidence to support it. But we do find that the pleadings in this case are helpful because it helps to demonstrate how plaintiff's counsel will try to attack internal investigations. And it helps us to tailor our approach to avoid some of these arguments from happening. So we thought it was important to include it and spend some time talking through kind of some of the things that have been highlighted related to the allegations here. So Julia Carrion was hired with Citigroup to work in the digital platform area. She made allegations that she was first sidelined by some male executives who were threatened by her work, and then later subjected to a hostile work environment based on her gender and sexual harassment in some by a senior executive with the organization as well, Andy Sieg. There's allegations that Sieg's conduct led to rumors about them having an affair and an inappropriate relationship in general. And HR investigated that. The other allegation that's pertinent here is that HR investigated this in what was repeatedly referred to in the complaint as a weaponized investigation, which ultimately led to Ms. Carrion resigning from her employment. And so, talking through, there are quite a few allegations about mishandling of the investigation that were highlighted in the complaint. And so, as Sasha mentioned on the last case she spoke about, I'm only going to talk about a few of kind of the big headline worthy ones that came out of those allegations, but there certainly are additional claims within the complaint document. One of the interesting ones here was related to a claim that the language used by investigators when they were interviewing Carrion was language that was considered to be sexist. And so the terms indiscreet and gossip, they made claims that during her interview, she was asked if she wasn't a gossip and if she was indiscreet generally, which her counsel claims in court documents that, this was a preconception and evidence of some bias by the investigation team. They also talked about failing to consider other witnesses and other evidence that Carrion had suggested during her interview. Part of the allegations that came out that they were investigating were about whether Carrion had obtained kind of special privileges from her relationship with the executive Sieg. And some of the questions that she was asked were really about, or she felt, at least as the complaint alleges, were about her character and judgment and decisions that she was making. And so she put forward the recommendation to the investigation team that a list of witnesses that she provided who could speak to her positive character be interviewed. And none of those witnesses were interviewed by the investigation team as part of the investigation. And so in her complaint, that is one of the many areas that are highlighted as a deficiency in the investigation that was conducted. She also talks about the failure for the investigation team to gather kind of basic information from their perspective before interviewing witnesses. Particularly, there are some allegations related to claims about her and the specifics of kind of internal corporate policies that they allege that the investigation team should have known and should not have had to ask her during the interview, which they claim was evidence that they were not properly informed. Similar kind of to the case that Sasha was just referring to, kind of this assumption that these investigators don't have a clear understanding of the policies and procedures within these organizations that they are investigating, and that has a negative impact on the investigation itself. Another allegation that came out in the complaint document were that there was uneven application of the policy. So while Carrion was bringing forth a complaint of sexual harassment against Sieg, there was an investigation kind of simultaneously happening about whether or not Carrion had benefited from her relationship with Sieg. And so during the course of the investigation, she was asked a particular question about her relationship with Sieg, and she responded by saying, well, did you ask Sieg that question? And what did he say when you asked him about the nature of our relationship? And the investigator, instead of answering her question, told her that Sieg was not under investigation and that she was the one that was under investigation. And so she needed to answer that particular question. And so in the complaint document, there is a very clear allegation related to kind of this uneven application of the policy as it pertains to investigating only Carrion and not looking into these allegations of harassment that she was putting forward against Sieg. So, ensuring that if we have multiple allegations that are pending at the same time that conflict, that we're looking into kind of all sides of the complaint that has been brought forward is a really important part, kind of aspect of what this claim particularly brings out, right? Because even if one came before the other, and even if the investigator has some inkling to believe that one of the allegations may, have some additional support at the onset, it's important to not be making these conclusions, right, until you've gained and collected all of the information that you can that's relevant to the allegations. And so, by virtue of essentially dismissing Carrion's question and telling her that only she was under investigation, there certainly seems to be a claim that that action essentially dismissed her own claims that she had brought forward and instead was focused on solely an attempt to, from her perspective, force her resignation or to create, kind of this negative reputation for her within the organization. What's interesting about the allegations about the investigation is that while she makes claims that the witnesses that she purported that they talked to were not investigated, they were not interviewed as part of the investigation, she also says that they investigated a lot of people who did not need to be investigated as part of the investigation, rather. They interviewed a lot of people who did not need to be part of the investigation. And from her perspective, failed to preserve kind of the confidentiality of the investigation itself by perpetuating this rumor that already pre-existed that she had raised concerns about an inappropriate relationship between her and Sieg, which she seemed to imply was not correct. And so, thinking about how do we make decisions about what list of people or potential witnesses that we're going to include as part of an investigation really can kind of come down to whether or not the investigation is questioned, right? So if we're going to make decisions that certain witnesses don't need to be investigated, again, it's about documenting the basis for those decisions so that if we are going to investigate witnesses who may, on the face of the complaint, not seem to be relevant, we, on the flip side, and looking at it, also have a justification for why we kind of expanded the list of witnesses that we may be interested in talking to understand more detail about a particular case.
Absolutely. And we can certainly talk about this a little bit more as we talk about best practices. But, Taren's last points about whether how to think about which witnesses get interviewed and how many and what information we're really looking for from witnesses versus, for example, from documents or other kind of background questions. That all, of course, feeds into a question of the scope of the investigation and how one determines the scope of the investigation, to what extent that's something that an investigator is bringing back to their client, that the client is dictating, et cetera. Okay, so one last case we wanted to talk about is, as I said, hot off the presses, to use a different media term, not a newspaper, but a TV station. But this case was just filed in May, so a month or so ago, by a news anchor who raised a couple of concerns that are all significantly related to a workplace investigation. So Ms. Dunham alleged both race and sex discrimination from the following actions. So one is she claims that she brought forward a complaint against a coworker who was of a different race and gender from her, and that the employer failed to adequately investigate her complaint against that individual. On the flip side, she claims that there was an investigation of complaints about racial bias that was filed against her, but that the employer's investigation of those complaints was incomplete, and the resulting decision that she had in fact engaged in conduct that she'd been alleged to have engaged in was faulty because the investigation was incomplete and therefore faulty. And then, so two different investigations at issue effectively. And in particular, as to that second investigation that I just mentioned, she claimed specifically that the employer had ended up falsely implicating her. Well, this is the term that she used, but basically falsely giving the impression that she was in fact racist. Again, the outcome of that investigation that did occur, because it announced her demotion sort of in a public area in public to other employees, and that demotion took place just after the investigation. So again, because similar to the Carrion case that Taren was just describing, the Carrion versus Citigroup case that Taren was just describing, there was an allegation that employees were broadly aware of an investigation, again, perhaps not being held sufficiently in confidence, that led to employees having ideas about why she was demoted as a result of that investigation that were all sort of, again, to her view, false. So this case is, again, brand new and sort of yet another example of concerns that are raised by employees relating to the conduct of workplace investigations, or the non-conduct, as part of this case alleges, of workplace investigations, that raises or that reminds us, I guess, about various ways that an investigation might be attacked, and various concerns that could be raised by the parties affected by an investigation that can lead to litigation in and of itself. So with that, we wanted to take some time now to sort of gather our thoughts a little bit and sort of go over, again, sort of at a higher level, the kinds of issues that came up across several of these investigations that we've already talked about, and to sort of reinforce some best practices that we consider to be important for really any investigation. I will just say, of course, that the way in which some of these best practices are implemented really will depend on exactly the nature of the allegations, of the investigation, of sort of the size of the issue, right? If what we're talking about is, I don't know, a team or department, of 150 people where the allegation is sort of widespread sexual misconduct, that's going to be a bigger investigation than a concern raised by one employee about one comment made by one other employee, right? Usually often those will end up being very different sizes of investigation, and the way you address some of the issues and best practices may sort of look a little bit different between the two of them. Having said that, to recall some of the scope issues that we talked about, and some of the concerns that, additional allegations maybe weren't considered enough, even in the case of an investigation that arises from one employee claiming one other employee made one inappropriate comment. If in the course of an investigation, additional information comes to light, it may well be that investigation really should expand and take a broader scope than initially considered. And setting yourself up with these ideas, these concepts sort of in place before either one of those investigations begins is going to be really helpful to ensuring that no matter the size, the investigation is sort of as well set up as possible to be protected from the kinds of criticisms that we've been talking about in these cases. So with that wind up, one thing that we talked about in a couple of the cases, and it's a very an issue that will come up at the very beginning is promptness, right? And so usually a good idea to begin investigation as promptly as possible after the company has been notified of a concern. And when I say the company, right, it's important to remember that some of these concerns are going to be raised to sort of intermediate level folks, but the company will have that knowledge imputed to it. So it's also important to, as you'll see on the right side of the slide, to make sure that folks are well trained to understand when information is coming to them that may be raising red flags, that may mean that some action may need to be taken fairly immediately. So it's important to consider how quickly an investigation gets going. And
Sasha, would
yeah.
it also be pretty important to denote why there might be a delay, right? Sometimes there are justifiable things that are happening, leaves or unavailability of witnesses or documents, etc., that might pop up. Can you speak to kind of how that also would, something that needs to be denoted?
Completely agree, and I'll tie it back also to something you said about one of the cases you mentioned, which is the documentation piece, right? In the moment, it may be blindingly obvious to everyone involved that the investigation can't quote unquote begin until some other thing happens, right? Whether this person comes back from leave or whether we get some additional information, or maybe like in the case of Sabatini and the Whitehead Institute, there was a culture survey going on. Maybe they considered it didn't make sense to be launching anything until there was some more information from the culture survey, right? But if you don't have that documentation in place, that's recording in some ways the reasons for those decisions, it's gonna be very easy for somebody to attack an investigation by saying, well, hey, I brought my complaint on July 1 and your investigation didn't begin until November 1. And if there's no record of why that gap, it's gonna make it harder to justify. So entirely agree with that. And of course, it may well be that the decision that's made early on is this is not actually a concern that needs a quote unquote investigation, for whatever reason, right? Maybe it's the concern is actually, just obviously a dispute about, some work document, right? That has, it's a process dispute, not a discrimination type dispute. Lots of reasons why a company might decide that whatever has come sort of to light is not something that that needs to be investigated. But on the flip side, being mindful that sometimes concerns come forward without the words harassment, retaliation, race, gender, et cetera, discrimination being upfront center in the complaint. Next thing I'll talk about is what came up again in a number of the cases as to neutrality. And there's various ways that can arise, but certainly is the first case we talked about, ensuring that your fact finder is not the same person that is providing guidance to folks who are either the accused or otherwise involved in the investigation. That certainly may take some advanced planning and consideration if you're a smaller business without a lot of bodies to go around. If you have an HR department of one or two, there may not be a lot of choices, but that needs to be taken into account before you get so far down the path where the investigator becomes, basically not creditable.
And there also might be times where there's no one internally that really can be truly neutral, especially depending on, the level of the accused, right? Sometimes it's someone at the highest level who really is overseeing the entire department that would be responsible for the investigation. And so sometimes in those instances, it really is about finding a third party who's external to the organization, because that's really the only way to ensure a level of neutrality for the investigation as well.
Absolutely. And another example actually is if the folks who are being accused are themselves in HR, then might be a real question about whether anyone within the HR organization can truly be neutral enough to conduct that investigation. So lots of reasons why it it may be a difficult thing to navigate, but certainly very important to try to figure it out early on. And then, of course, things may change and a new allegation may come around, and the person who you thought was neutral, suddenly is it's harder to defend them as being neutral, and so you may have to pivot. So something to think about sort of throughout the course of investigation. I've certainly talked about training in the sense of training managers to be aware of when concerns and complaints are coming in, and whether something needs to be elevated to the point of having an investigation begin. Of course, it's also important for the person engaging in the investigation to frankly know what they're doing. It isn't to say that you can't have someone who's never done an investigation by themselves have for their first time an investigation. I mean, there's literally no way to ever become an investigator if you don't do your first one. And so what was interesting about the one of the cases we talked about is the first the investigator, it was their first investigation, and they were overseen by somebody else who was a more experienced person. That may well be okay in another situation. The jury didn't think it was okay because in this situation, not only was this their first investigation, but they actually hadn't really even gotten much sort of objective training, right? So it's one thing to be doing your first investigation, but maybe you've sat in on several, or you've been extensively trained. It seemed to not have been the case here. And then the other piece of sort of the training piece, or maybe sort of background information piece, right, is making sure the investigator has a full understanding of the policies at issue and really what they mean before they launch into the investigative process. I've talked about scope. I won't belabor that point too much, but of course, it's something that is important to be mindful of all the time. And throughout the investigation, and in particular, what Taren mentioned about, and actually maybe what we both mentioned about a couple of the cases that the complaining parties considered that they had brought other information that should have been investigated, but in fact was not. If there is a decision that is made by the employer in the course of the investigation that some additional allegation, it's not appropriate to be handled within the course of that investigation, that well may be a perfectly fine decision to make. But to Taren's other point, be sure that it's well documented so that down the line, if that decision is ever questioned, you have something to look back to and to explain why that decision was made. We talked also about confidentiality, and that, of course, can come up in lots of different ways, including how expansive the investigation is or maybe has to be by its nature, or really whether there's some information that can be gathered that doesn't require expanding the universe of people who know that there's an investigation. For example, by reviewing documents, by talking to somebody who's already sort of in a confidential position who may have that background information. And one more point before I turn it back to Taren will be, thinking about how conclusions are reached. As I said, there is no legal requirement for investigation to be perfect, but judges and juries will be looking for it to be reasonable and in good faith. And generally, a judgment won't be second guessed unless there is some indication in the way the investigation was conducted, or ultimately in what conclusions were reached, that in fact the investigation was a sham or a cover-up or an excuse for taking the action that was predetermined. Oh, Taren, you're still on mute.
A few more best practices to keep in mind relating to, what we've discussed today. So one being language, right? That specifically came out in one of the cases about word choice with questioning and how the language is impacting the experience of the person who's being interviewed, and how it might show some prejudgment or bias on behalf of the investigator based on how we are wording some of those questions and how we are asking certain things and for certain information. Also experience, obviously Sasha talked about training. but just generally, right? The experience, has this person conducted these investigations? Have they been involved in investigations? Even if they haven't done an investigation on this particular topic, maybe they've done a half dozen investigations in something very similar or on other policies that the company has internally as well, so that they can really speak to understanding the process, understanding the typical procedures and practice, and how things are normally run with an investigation at the particular organization. And then just generally fairness, right? So understanding, that courts and juries are really evaluating whether the process seems fair, right? Whether there was a review of the allegations that were made, how that information was assessed, what particular information was considered and what was not considered, particularly where we talked about, the witnesses that are brought forward by individuals who are either the accused or the person bringing forward allegations. Were the decisions that were made, were they fair? Is there some level of equity that seems to be happening with the decision making and how certain things are impacting the outcome? Because really ensuring that you have a fair process can help to strengthen the investigation as a whole and to create additional defenses for the organization should the investigation be questioned at some later point, including in litigation. So we do have a few minutes for, questions if there are any. We want to, of course, ensure that we're also sharing the SHRM and HRCI activity codes, which you'll see on your screen right now. But if anyone has any particular questions to share in the chat, we're happy to answer those with the minutes that are remaining.
And while we wait for some additional questions that may come up, one thing that I know, Taren, you and I talk about all the time, but that I think we hadn't quite mentioned yet is sort of how do you make these decisions, right? I mean, we talked about a lot of these best practices, but at the end of the day, how they get implemented comes down to somebody having to make a decision. Are we going to launch an investigation or not? Who are we going to use? Those kinds of things. So, I'll give you my quick take on that, and then I would be great to hear from you, Taren, also on what you think on this. But especially if it's an outside investigator, like the kind of work that you and I conduct, but certainly even outside folks, what I always hope and expect to see happening is, a healthy dialogue that is helpful to trying to figure out what is the right answer to these questions. Now, of course, an outside investigator, a neutral fact finder needs to maintain a level of independence and not end up being so constricted and directed by an employer that, once again, their investigation looks like it was a sham and just, the outcome was directed by what the company wanted to happen. But on the other hand, an investigator shouldn't necessarily be making all these decisions about the scope and whether some additional policy is relevant and who all should be interviewed. So I think it takes a healthy dialogue. Taren, anything else you wanted to throw out
Yeah,
there on that?
no, I think that's exactly right. And I think particularly where we talk about scope, for example, I think I go back to ensuring that we're explaining the scope and why it was expanded or at what point it was expanded within the actual report document, right? So identifying that there are reasons why certain things were added and certain things might not have been. We also have to be realistic about costs associated with an external investigation. And so sometimes there are completely unrelated allegations that may come up during investigation that can, in fact, be investigated by the internal legal or HR team within the organization. And so sometimes decisions on scope are that simple, right? That this is something that the organization, if it had independently received this information as a complaint, as opposed to it being part of an investigation interview, would have conducted the investigation internally. That certainly can be done. But I think it's important to make sure that we're just denoting that in the report so that, again, if those things come up as questions later, there is a justification or a basis for that.
Totally agree with that. Um, we are seeing lovely number of questions, and they are raising great questions. The ones
Yeah,
I'm
I see.
seeing so far, but Tara, maybe you spotted one. They seemed a little
Yeah.
bit more specific than it might make sense for us to cover. But if you've got one, go ahead.
Yeah, there's one that says, what are your thoughts on letting interviewees knowing what role they play in an investigation, such as whether they are a witness, the subject, etc.? And should the investigator say during interviews what the specific allegations are, or allow interviewees to come to that conclusion themselves based on the questions? So immediately, the answer for me is it depends on who you're interviewing, right? But certainly when you are interviewing the accused, there's really a due process component to it. And so they should be made aware that there are allegations particularly being made that they have violated policies and that the investigation is including allegations against them. And you should also ensure that you are very specifically outlining what those allegations are so that they have an opportunity to respond to those allegations. In terms of, talking to general witnesses who are purported to be people who just have information about the investigation topic, we have to be more careful, right? This was really the subject of some of the scrutiny that came down on some of the investigations we talked about whether there's a need to know the particulars of the actual complaint itself, right? And the details of the complaint. And so it is a little bit fact specific in assessing it, but particularly for the accused, you want to make sure that they have a full picture of all of the allegations and a full opportunity to respond to those claims.
Couldn't agree with you more. And I'll just mention that, it's certainly an easy subject for a plaintiff and their lawyer to pick at to say, well, I was accused of these things. I didn't even know what they were, and nobody ever gave me an opportunity to, give my side of the story. So definitely a great point there, and something to be avoided. So with that, we have reached the end of our time with everyone. Thank you all for joining us today. It was lovely to have your participation in the questions. And thank you, Taren, for joining me as well.
Thanks, Sasha.
Take care.